If my child has an IEP, can she still be suspended?
Yes. Children with disabilities can be suspended for up to 10 days in a school year without any special protections. After that, some protections are in place to protect children with disabilities. The guiding principle is that children with disabilities should not be suspended for behaviors caused by their disability. However, if the misconduct is not caused by the child's disability, the child can be suspended the same as a non-disabled child. Even if the child is suspended, though, his school district must still make sure that he receives a free, appropriate public education, a FAPE, while suspended.
What happens if my special education child is recommended for a suspension of more than 10 days?
First, parents should get a written notice of what happened that led to the suspension and what length of suspension is being recommended by the principal. Parents may wish to schedule a personal meeting with the principal or assistant principal to discuss why a suspension is being recommended. Principals may impose suspensions of 10 days or less. They may recommend longer suspensions to the superintendent, but only a superintendent may impose a suspension of 11 days or longer. Then, the school should schedule a Manifestation Determination Review, or MDR. The purpose of the MDR is to decide whether a student's misconduct was a symptom or manifestation of the disability. This meeting must occur within 10 school days of the suspension. The student will be suspended during this 10-day period. Following the MDR, the student will be able to return to school if the team finds the misconduct was a manifestation of the disability. However, if the team did not make that finding, the suspension will still be in place. All students have the right to appeal a long-term suspension and have a hearing. The issues at an appeal are different from the ones at an MDR. At a school suspension appeal, the issues are whether the student did what he was accused of doing and whether the length of the suspension is proper. Each school district has slightly different procedures for the appeal hearings. The procedures can be found either in the school board policies, on the school district's website, or in the student handbook.
What is a Manifestation Determination Review, or MDR?
A Manifestation Determination Review, or MDR, is a special type of meeting that the IEP team must hold if the student is facing suspension of more than 10 days in a school year. The purpose of this meeting is to determine if the behavior that led to the suspension is a manifestation or symptom of the student's disability. If it is, the student may not be suspended for the conduct. At the MDR, the IEP team, which includes the parents, must address two questions. First, was the conduct that led to the suspension caused by or substantially related to the child's disability? Second, did the conduct arise because the child's IEP was not being implemented? If the answer to either question is yes, then the conduct is determined to be a manifestation and the student may not be suspended for it. In making the decision about whether the conduct is a manifestation, the team should review the student's evaluations, IEPs, discipline history, any behavior plans, other information available about the nature of the student's disability, and the reasons he was declared disabled in the first place. If the student was determined to be disabled because of consistent behavior problems, and the behavior that led to the suspension is similar to the behavior that resulted in him having an IEP, then the behavior likely should be found to be a manifestation of the disability. On the other hand, if the student's disability does not relate to the behavior and the student has never violated school rules before, it is not likely to be considered a manifestation.
What happens if my child's conduct is found to be a manifestation of his disability at an MDR meeting?
If the IEP team finds that the student's behavior was a manifestation of his disability, the student should go back to school. The team should consider changes to the child's IEP that will help the child avoid misconduct in the future. The IEP team should consider having a functional behavioral assessment and/or implementing a behavior intervention plan. There are 3 exceptions to the rule that a child must return to school if his behavior is a manifestation of his disability. A school can suspend a student with disabilities for up to 45 school days, even if the student's action was a manifestation of his disability, if the student had a weapon at school or at a school function, the student had illegal drugs at school or at a school function, or the student seriously injured another person at school or at a school function. However, even if one of these three conditions exists and the student cannot return to school, the student is still entitled to education, just in a setting other than his regular school, such as an alternative learning program or setting or at his home. At the end of the 45 days, the student should be returned to his original school placement unless his placement has been changed by the IEP team at an IEP meeting.
What happens if my child's conduct is found not to be a manifestation of his disability?
If the misconduct was neither substantially related to the student's disability nor the result of the school's failure to follow his IEP, then the student can be suspended. If the parent disagrees with the decision of the team that the conduct was not a manifestation, the parent can use one of the dispute resolution tools. Specifically, a parent could ask for mediation or could file for a due process hearing. In due process cases involving MDR decisions, the judge in the case is required to speed up the usual process so that a decision can be reached quickly. If the suspension is for longer than 10 days, the underlying suspension itself may be appealed through a process set up by the school district. A suspension appeal is appropriate if the student denies that he did what he is accused of doing or believes the suspension is too long. Suspension appeals are handled by the school administration according to the procedures spelled out in the student handbook. Even if the student's suspension is upheld, the school district must continue to provide education to the student so that he can continue making progress on his IEP goals. This can occur in any setting other than the child's regular school. There are no precise rules on what this education must consist of, other than allowing the student to continue to participate in the general curriculum and make progress on his IEP goals.
What is a functional behavioral assessment, or FBA?
A functional behavioral assessment, or FBA, is a method of looking at behavior to understand why the child behaves the way she does and how the world around the child affects the child and the behaviors. Best practice with regard to an FBA is to have it done by a trained observer, not the student's teacher. The Center for Effective Collaboration and Practice has an excellent website regarding FBAs. Steps included in a functional behavioral assessment include identifying the problem behaviors, collecting data about the behavior, identifying the function of the behavior, and developing a theory that explains why and when the child misbehaves. From the data, a good behavioral intervention plan, or BIP, can be developed.
When should a functional behavioral assessment, or FBA, be conducted?
A functional behavioral assessment must be conducted following a manifestation determination review when the team has concluded that the misbehavior was a manifestation of the disability. If an FBA had been done previously and a behavior intervention plan is already in place, then the team can revise the behavior intervention plan rather than complete a new FBA. If the behavior leading to a suspension is found not to be a manifestation, the IEP team should determine if conducting an FBA would be appropriate under the circumstances. The goal is to put a plan in place that will help the student avoid future misconduct.
What is a behavioral intervention plan, also known as a BIP or BIP, and when should it be used?
A behavioral intervention plan is a plan that is developed from the results of the functional behavioral assessment. It is primarily a plan for the teacher and other adults to help them adjust the surroundings and their reactions to a child's misbehavior. The idea is that if the situations and triggers that result in the misbehavior are changed, then the misbehaviors will be reduced. Similarly, if the reactions of the adults are controlled so as not to escalate the behaviors, the individual incidents of misbehavior become less disruptive. Often, a BIP will include positive supports such as direct instruction about replacement behaviors, rewards for desirable behavior, and the selection of a caring adult to provide positive support during difficult times. The plan may also include changes to the environment to keep the behaviors from starting in the first place. Consequences for repeated behavior can be included in the plan, but they are not the main goal. The plan should also specifically identify who is responsible for which parts of the plan. A good resource for BIPs can be found at the website for the Center for Effective Collaboration and Practice.
What should I do if my child is repeatedly getting sent home early from school?
Under the IDEA, being sent home early in response to misbehavior is called a disciplinary removal. You should keep records of the amount of time the child is being removed from school. Under the law, a child with a disability may not be removed from school for more than a total of 10 days in a school year without getting the benefit of the IDEA protections. These protections include having the team meet for a manifestation determination review, or MDR, to look at whether the misbehavior is a manifestation of the child's disability. If it is, then the removals must end. The parent can insist that a MDR be held for each removal after the total amount of time removed from school reaches the equivalent of 10 school days. If the school refuses to hold the MDR meetings and continues with the early dismissals, the parent should consider filing a complaint to the State Department of Public Instruction Exceptional Children Division. This type of removal from school is unlawful.
Can my child be charged with a criminal offense for something he does at school?
Yes, if the conduct violated the law. Nothing in the IDEA protects a disabled child from being charged with a juvenile offense if the child is 15 years old or younger, or a criminal offense if the child is 16 years old or older. Under North Carolina law, a principal must inform law enforcement when one of the following 9 incidents happens at school: assault resulting in a serious personal injury, sexual assault, sexual offense, rape, kidnapping, indecent liberties with a minor, assault involving the use of a weapon, possession of a weapon, or possession of a controlled substance in violation of the law. For other offenses not listed above, the principal or school resource officer can decide whether to report the incident to law enforcement.